What you can do? What you can do? What are you going to do when they come for you? Will you remain silent or will you speak? What are your rights? What do you do if they arrest you? Do you have to go with them? Do you have a right to a phone call? Do you have the right to brush your teeth? How long should they keep you? 24, 48, 72 hours? Do you know? What do you do if they get a little rough with you? Who do you tell? When do you say it? What are your remedies? Well, all will be revealed on the legal brief. Thank you for joining us. This is The Legal Brief, and I'm your host, Ramona Farquharson. We will be discussing criminal law from arrest to arraignment. And to join me would be Mr. Roger Thompson, Chief Superintendent and Director of Legal Affairs of the Royal Bahamas Police Force. Welcome, sir.
Thank you.
As well as Mr. K. Melvin Monroe of Themis Law Chambers. Welcome, sir.
Thank you.
Let's get right into it. Hot topic that everyone wants to know about, from arrest to arraignment. What information ought to be provided by the police to any civilian when stopped? Mr. Thompson.
Information that needs to be provided by the police?
In stopping someone, what should be said to them, if anything? The police stops you.
Okay, it depends on what the police stop you for.
Okay.
If the police is investigating a complaint, a crime, judges' rules provide that a police officer can question anyone to obtain information pertaining to any crime they're investigating. So
any offense?
Yeah, any offense. So a police officer can actually approach anybody. That does not mean the person is under arrest, doesn't even mean that the person is suspected of doing anything. It just means that the police can approach you and ask you questions whether you have information to assist them.
So I'm clear. Does it mean that the police have the right to stop you? Let's say you're driving or you're walking. Does the police have the right to halt you and stop or impede your travel?
A police can stop a vehicle if they suspect that you committed an offense. If you are suspected to have committed an offense, yes, the police can stop you. If you did not commit any offense, I do not see the police stopping you unless it's for some social reason, maybe to...
Social reason?
Well, the police have a lot of programs going on. Sometimes they stop vehicles to give them certificates of, they have this program said Good Drivers Award. It's a program that you'll find that the police have sometimes. Sometimes you will have flyers or crime prevention tips. So stopping a vehicle is not always about crime. Sometimes it's about tips, sometimes about award, and sometimes about valuable information.
But generally, for our purposes here, you're saying then a police officer ought not stop a civilian unless they're suspected of committing some offense.
Not just, no. Offense or information.
So if they wish to have information or there's an offense.
Yes.
So now we come naturally to this point.
Right.
What information would one be compelled to give to the police that you must answer?
Okay. The word compel.
You want to shy away from that?
It's
Too strong?
It's a strong word.
Okay.
And I'll tell you why I say strong. Yourself, my learned friend, Mr. Monroe, and all your neighbors, you all form the community, the public. And the police actually is a servant to the public. So as servant to the public, you should never be compelled to speak to your servant because we serving you. it's a partnership. So really, what I would say, to assist the police, I wouldn't say compel. The good citizen of the Bahamas and visitors to the Bahamas, anytime you have an encounter with the police, it's really to assist the police to provide a better service to you.
So, okay, come now. That sounds, I think you got that down pat, of what you're saying, but I want to go a little deeper with that. Mr. Munro, I'm going to draw you in here. When a person is stopped by the police, my understanding is the police, they ask you your name, address, you are compelled, you ought, in fact, if you don't do it, that can be an offense. What say you?
I agree. The law provides that once stopped by the police and police ascertain that information, your name and address, that you are obligated to provide that information to the police. And it goes even further. It says that if the police believe that the name and address you give is false, it creates an offense.
So it's not, so I think, Mr. Thompson, I hear you talking about partnership and servant, but I think, really practically speaking, when a police officer say to you, what's your name? And let's be, I want us to be very...
Let's be realistic.
Let's be realistic because we're talking to audiences. You're talking to particularly young Bahamian men who are driving around, and they know when the police tap on that car or turn on that horn and say stop or pull over. This ain't about being no servant and friendship or partnership.
But I say that for a reason.
Yes.
90%, 99% of the people in the Bahamas are good, decent people, and that's what I believe. There are a small segment in this country who are involved with criminal activity. So I'm saying, as a public generally, when a police officer approach you, you are to see the police officer as a partner with you. Now, let's deal, you're talking about the criminal aspect.
I'm talking about the law, yes.
Yeah, the small percentage of persons who are involved in crime, not the majority of Bahamians, the small percentage, I believe, who are involved with crime. If they committed an offense in the presence of a police officer, the police officer can arrest you. If an officer asks you for your name and address and you refuse to do so, you can be arrested. If you commit a traffic offense, an officer asks you your name and address and you refuse to give it, you could be arrested.
I think you could even be arrested if you don't give them, I think it is your driver's license.
Yes, even if your driver's license, or even if you don't give the location of your employment, you could be arrested. Yes. Of course, if you don't have it on you, you could be given 24 hours to produce it, but you can be arrested.
If you don't produce it,
if you don't produce it.
And so I want to say to you, I hear what you're saying as well, and and I understand you want to say, listen, the police are partners, and that is something that, of course, they've been advertising and they want because they want their assistance and to have foster good relationships with the community. But again, when we're talking about the law, the average servant, if you're using your words, the average servant or does not, civil servant, public servant does not have the right to arrest, but the police, they do.
But see, even with citizen, if a police officer see a crime being committed, a police officer can actually call any citizen to assist him in arresting an individual. And that person who he calls have the power of arrest.
Yes, citizen's arrest.
Yes. So, but I still hold fast to this partnership with the community because I believe the majority of good citizens in this country, they are good citizens in this country, and a small percentage of people are involved in crime.
So let's moving along from there now, Mr. Munro. Let's look at the police have stopped you, and they've asked you for your name, address, all of that. You've provided that. Now they invite you. They say, "I'd like for you to attend the police station. I want you in the morning to attend CDU, Central Detective Unit, wherever the case may be." What are your rights at that point? Is there a difference between an invitation and an actual arrest?
Before I answer whether there's a difference, if a citizen is stopped by the police, I hear counsel talked about either an offense or information. An officer should say to that individual, once they are stopped, the reason for them being stopped.
I agree with you.
Before even asking anything of them.
Mm-hmm. Why I stopped you?
Yes, that's the first thing.
Mm-hmm.
When it comes to information, as counsel stated, it's a difference. You don't have officers lining the streets with pamphlets and documents to say, we're going to stop members of the public to distribute information.
Actually, it's never happened to me, but
I'm trying to understand in what real world counsel is talking about stopping people to give them information.
Okay. There's a program that that the police has been launched for a little while now. Okay. The Good Drivers Award Program, where the police officers are on the side of the street and they have stopped some drivers and they're giving them a certificate that they are good drivers. Not every encounter with the police is pertaining to crime. That's the point I'm making.
Yeah, that's what you're making.
Yeah, I'm making that point.
Sad
yes. So, yes.
Albeit we've never been stopped for good driving awards, but I do hear you. So now, and granted, so here it is now, Mr. Monroe, you've been stopped. The police have told you why they've stopped you, and they now invite you to the station.
If it's an invitation, you could decline an invitation. That's automatic.
So many people don't know that they have the right. And do you accept that, Mr. Thompson, that you can decline the invitation of the police?
You can decline invitation of the police, provided that you are not suspected of committing an offense.
Now, one moment there. Either it's an invitation or it's an arrest. I'm speaking about an invitation.
Yes.
I want to see you at the, or even if it's not even a stop, a phone call. Sometimes officers will call. I've had clients say they've called and they said they'd like to see me at the station at such a time. That's an invitation, is it not?
It is an invitation.
And you can refuse that.
Yes, but if you are a suspect of a crime,
yes,
and you are invited, as opposed to the police coming to your home and arresting you, you suspected a crime and you receive an invitation, not an arrest, and you refuse to come on the invitation voluntarily, it may move to you being arrested.
And will you be informed of that? When the invitation is given, are you told, well, if you know you don't come in, then we're going to have to come and get you?
Well, see, I cannot say exactly how an individual officer will
phrase it.
Will phrase it, yes. I can't say.
But we're all on one page that an invitation can be refused.
Yes.
But you say it's open to that officer, if you do refuse the invitation, to now come and arrest.
Yes.
Before you comment, because I know you want to add to that, we're going to take these important messages. You're watching The Legal Brief.
Health officials announced early on that the coronavirus court
and Q.
A fire had erupted at the
all of the victims have lost their lives.
And we're back. Gentlemen, we left off speaking about if an invitation is given and the person doesn't avail themselves, they very well may be arrested if they are suspect of crime.
Yes.
And so now we're at the point of arrest. And Mr. Monroe, I want you to expand here. What are your rights upon arrest?
You have a right to know the reason for your arrest as soon as practicable.
So we're talking then about a caution?
Yes. the caution comes after you are informed of the reason for your arrest. And with that caution, which comes from the judge's rule, once the person is cautioned that they have a right, they're not obliged to say anything unless they wish to do so. But whatever they say may be taken into writing and given in evidence. Yeah. One must know that once arrested, they don't have to speak to the police.
Silence.
That's it.
Is silence golden?
Sometimes.
Okay. Mr. Thompson.
Well, he is correct. Once you are arrested, you ought to be informed why you are arrested. You should be cautioned once you're arrested. You have a right to remain silent. That is so true. But I would say that...
You like buts.
Yes.
But go ahead.
Yes. I would say, even though you have a right to remain silent.
Yes.
And if you are innocent and you know that you're innocent.
Watch yourself now.
No, I'm going somewhere. You know you're innocent. There's nothing wrong with you saying that I'm innocent.
But you have that right.
Yeah, that's your right.
You have that right.
That's your right.
No, you don't have to declare your innocence or say that I'm innocent. Because again, you have to prove some things, yes?
Yes. Well, actually, the police have to prove that you are guilty if the police suspect that you are guilty of something.
Well, certainly you would think that they should have something sufficient before laying a charge. But even before we get there now, we're at the point of arrest. So your mindset is, and you wish persons to know, listen, even though you have the right to remain silent, if you are innocent, have nothing to hide, because I hear that a lot. My clients say that the police tell them that a lot. You have nothing to hide. Talk to us.
What I am saying is that you have a right to remain silent.
Yes.
But it does not mean that if you know you are innocent, you have not committed any crime. It does not preclude you to saying, officer, I do not know this XYZ. I wasn't there. I was someplace else. That is your right to remain silent. But if
trying to get from you, Mr. Thompson, that persons who are guilty are the ones who really should remain silent. Are you getting that, Mr. Monroe?
Kind of.
No. I'm just saying that. From my experience, you find that persons who are truly innocent, in my experience, who are clean hands and so forth, they tend to be more forthcoming.
More open and talking.
Yes. My experience have been that persons who have something to hide tends to be the ones who remain silent quicker.
Mr.
My
Monroe,
experience.
Has that been your experience?
No, it has not been my experience. What I've experienced is that police officers, for the most part, when it's time for an investigation, their investigation starts with an arrest. Whereas an arrest should be the last or almost the last part of an investigation.
Interesting.
So when they bring a person in custody, the investigation just starts. They're asking this person questions that they have no information on. That's an issue.
And you feel that that's improper.
And it's fundamental when it comes to investigation to allow, when there's a suspect, to be almost the last part of that puzzle.
Yes, I've heard that before, that really the questioning ought to be last, whereby you don't even need them to answer or not, because you already have all of your information. Your investigation is done. Yes. But again, do you agree with that?
I don't.
What's your view?
I don't. The Royal Bahamas Police Force investigate. This is my belief. I haven't seen anything to contradict me personally.
Yes.
They investigate every complaint that is launched, so far as I'm aware of. And once there's sufficient evidence that this particular individual may be responsible, or there's suspicion, reasonable suspicion, that this particular individual may be responsible for the offense, then that person is arrested. While, even though that person, even though additional inquiries may be required, that person normally is arrested after there would have been some initial investigation, which led the police to believe that this person may be responsible.
Right.
Yes.
I totally disagree.
Okay.
And the reason I disagree is because I've had numerous experiences where a crime happens in an area and the police come in the area and round everybody up, most of the males. And after rounding them up, that is how they start to conduct their investigation. And you find persons being in custody 2 days, 3 days, getting extensions up to 5 days, and then being released without a charge, sometimes without even being interviewed for a particular offense. Some of those persons went, filed actions against the police force, and was successful because the police did not have reasonable suspicion to arrest these persons. That's the first thing. You must have reasonable suspicion.
Yes.
You cannot just go and arrest persons. Take away their liberty, inconvenience them. Some persons lost their jobs with this inconvenience. How do they get these things back?
Have you found that happens on a, well, have you found that it's happened at all?
I cannot speak to his to my learned friend's
That's what I'm
experience.
asking. Have you experienced that?
Yeah, I haven't. But I can't knock his experience. He may have his experience and mine is different than his.
Mm-hmm.
So I do not want to say it doesn't happen. I don't want to say it never happened.
But you don't know if it happened.
No. Generally speaking, the matters that majority of the matters that came before me, there was initial investigation. Mm-hmm. Now, of course, persons were arrested and additional further inquiries were conducted.
But you do accept that there has to be, the law states, there has to be reasonable suspicion before arresting, not just a general roundup as if we're going to go on a fact-finding or fishing expedition. Well, that ought not to happen by the police.
Well, but I do know that there have been occasions, depending on the circumstances, where multiple persons may have been arrested because multiple persons may have been suspected.
Right.
There are times when multiple persons will be suspected of having committed an offense or maybe aiding and abetting an offense, and multiple persons were arrested. That's a fact.
So I'm getting, and certainly this has been great because we're now getting, upon arrest, well, first of all, you ought to be told why you've been stopped or why you've been arrested. Right. Obviously, you're cautioned, you're told you're right. And one of the things is you have the right to remain silent, even though we have different views as to when to exercise that, but you have the right to remain silent. The next thing would be, what about rights to consult? Do you have a right? I hear a person say, give me my phone call. You know, they watch American television. Do persons have a right to make a phone call once they've been arrested?
You have a constitutional right to consult an attorney of your choice.
Does that equate to being allowed to make a phone call? Because obviously if I'm arrested, I need to reach out to that attorney. Yes. So does it follow then that I ought to be provided the facility to reach that counsel?
Of course. That's the only way you're going to be able to reach a counsel is by a telephone call.
Yes. So you accept that, Mr. Monroe?
I accept that. Yeah. It don't mean it happens in every instance.
Certainly, I gather your experience is quite different from that of Mr. Thompson. Yeah. But so we have the right to remain silent, a right to consult, and then also I want us to explore about the right. Let's say you find parents show up to the station and they want to see their child, whether they're a minor or not. Right. Do you have a right, as a parent, you show up, your child is under arrest, to see that person?
A juvenile, yes. A juvenile has a right to see his parent or guardian.
Yes.
That's a constitutional right. Yes, that is
if you're
true.
not if you're not a juvenile, you're 18.
An adult will, the Constitution doesn't speak to adult with parent and guardian.
Right.
It speaks to you having a right to consult an attorney.
Right.
That's an adult. Juveniles have a right for parent and guardian.
So then I take it you would say that therefore that no, a parent would not have the right or not, and it's not the parent right, it's the person who's in custody,
it's the person
the
who's in custody.
person.
Yeah.
They do not have a right to see a parent if they're an adult.
They don't have a constitutional right. It does not mean that they will not see their parent or guardian. Just
but
that,
they're at the they're then at the mercy of the police, whether that's going to happen or not.
I think in most part, if it's not going to interfere with the investigation of the case, if it's not going to result in harm to the case itself, I do not see a police officer refusing a parent from seeing their loved ones.
Mr. Monroe,
Yeah.
talking about rights.
It's not a right.
It's not a right.
Not a right. So you accept it's not a right.
It's at the discretion of the officers, depending on the circumstances. And as he rightly said, if it is a situation where it will hamper the investigation, because we have to strike a balance.
Yes.
And we have to, be fair in the circumstances.
Because we're talking about being servants of the people and the partnership. And so there's a human aspect.
Yes.
Before we go to the break, I want you both, though, to touch on this because this is a pet peeve of mine. Do persons in custody have a right to brush their teeth and to freshen up? They've been in custody for days, particularly women as well. Do they have a right
constitutionally, you have a right, not to be exposed to cruel and degrading treatment. Mm-hmm. And if a person is in custody for a certain period of time and not given the opportunity to be able to freshen up and do certain things, deal with their hygiene, then that's an issue. It's clearly an issue.
Do you accept that, Mr. Thompson, that ought to happen? Should be allowed to brush your teeth, freshen up. Women may be in a certain condition, should be allowed to attend to their needs, hygienic needs.
I have no issues with that. And what happens, is when I used to be at the stations, the person in custody would ask to use the facility. The officers would then open the cell, allow the person in custody to go into the restroom, and when they're in the restroom, they can do whatever they need to do in the restroom. Whether it means washing up, or whether brushing their teeth, using.
I love to hear that. That's refreshing to hear that, particularly coming from you, as director.
Yeah.
And I hope that a lot of officers will be tuning in and listening to that.
Yes.
To know that persons ought to be treated with a certain level and modicum of respect.
What you missed, he said when he was in the stations, these are the things that were happening. How long ago was this?
Mr. Thompson, I take it from Mr. Monroe that may have been a long time ago and that's no longer the practice.
No, I'm not. I have not received any information that has changed. It's actually for standard orders. It's policy. Anytime, and it's just being human. Mm-hmm. If someone is in the cell and they need to use the restroom, as long as opening that cell is not going to expose the officer to danger, is not going to expose the person in the cell to danger,
yes,
then they will come out the cell, you allow them to use the bathroom facility, and they can do whatever they need to do in the bathroom facilities.
And so we're talking about, and I said, brushing teeth and that sort of thing. Family would be allowed to bring toothbrushes or toothpaste for them to freshen up, and women to do certain things.
I will tell you with toothbrush, me personally, I'm a little skeptical because persons can use the edge of the toothbrush as a weapon.
Right.
So you have to be very careful what you give to someone in custody, especially if that person is prone to cause harm to someone else. So you have to be very careful. I have no issues giving a toothbrush that is not going to cause injury to the person in custody or to the officer. But we don't.
You think within reason, so,
yes,
so there you
have
got
to be
consider
careful
that
you don't give a weapon to someone
of course.
in custody.
Yes, Mr. Monroe, you concur with that?
My position would be, if a person needs to brush their teeth, then if you don't give them a toothbrush, then what would they use?
I guess their finger or
then
something.
Then you have to also look at the officer being on alert, doing his job properly, because a person shouldn't be deprived, dealing with their hygiene because you are of the view that this may be the case or the next thing may be the case. Because if an officer is doing what he's supposed to do, he would be aware to prevent certain things from happening.
So you're saying brush your teeth and then I make sure I take the toothbrush back and it's intact.
Yeah, because you have a distance you'd be from that suspect.
Yes.
To be able to see the suspect, safe distance, and also see what was given to the suspect to ensure that nothing changed.
Right.
Those things, once that happen, then they should be able to deal with the hygiene.
So I take it for the most part, we tend to be agreed as to persons, and you've indicated, and that was interesting, you talked about the force orders that, and because when I'm talking about rights, I want to know what is written, what's etched there, not just at the behest or the whim of whichever officer is on. So we're looking then at our constitutional rights, or if something is enacted in or in precedents such as judges' orders, and you're talking about the 4 standing orders,
yes,
where it's actually written and codified,
yes,
where these persons in custody, the detained person, because again, you're not guilty of anything, you're just detained, you're just suspected, the police suspects you, so you do have rights.
Yes, you do.
Yes, and 2, before we go to the break, can we just touch a little on how long can you be kept in custody? People think just standard 24 hours, but how long can you be kept in custody?
The starting point is 48 hours, that's 2 days. And by extension, up to 72.
Yes.
Which would be a total of 5 days.
Yes.
The only issue with it is that when they get an extension, it's not according to the criteria that are set for an extension. It's a situation where if they think they need to get an extension, they just prepare a fiat, take it to a magistrate, and have it signed.
Sometimes even 2, I think justice of the peace. Sometimes I've seen 1 or 2
and the thing about it, it's never really tested to see whether or not the reason for the extension should be granted. And that is something that needs to be looked into.
Yes. Do you accept that, Mr. Thompson?
No, I can't accept that.
Why am I not surprised? Why don't you accept that, Mr. Thompson?
Because unless I see a particular case where that has occurred, I have not experienced that personally, where extension has been obtained.
Or abused?
I have personally not experienced that. So I cannot accept that. I can only speak to my personal experience. I can't accept that.
Mr. Thompson.
The presumption is that everything was done properly, that there were reasons why, there was the legal reasons for the extension. The extensions were granted, which is the parole officer has to secure and preserve evidence. That's one of them. Officer has reasonable ground to believe that a person detained may interfere or cause harm to evidence or other persons connected. Next criteria, the police officer believes that a person detained may alert other persons suspected to be involved, which is very common. A lot of times that if this person is suspected, that if this particular suspect is released, he is going to alert the other person who is being sought that the police is on to him or the police is aware of this or something like that. And sometimes you get extension because you don't want him to alert the other person who you're trying to capture, which falls under the armpit of the extension.
It's interesting that he says this.
Yes. Yeah.
Because at every juncture, when they make an application, the affidavit never specifically states these things. never call persons by name who they are seeking. They never, ever specifically make mention of these criteria to say or to show that, listen, it's reasonable in the circumstances. The extension should be granted.
Yes.
It's always blanket. And that's an issue.
Again, Mr. Thompson, have you seen the applications for the extensions?
I cannot.
You don't concur?
My learned friend may have seen something different than I would have. So I can't speak to his experience. But my experience and his experience are different.
Totally different.
They're different, yes. They're not the same.
Well, this is very interesting. When we come back, we're going to hope to see or see if we can reach some ground where maybe your experiences are tying in more closely.
I see.
On the legal brief.
Welcome to a world of art, a world of entertainment, and a kaleidoscope of cultural expression. It's a new season of A&E Showcase. Allow us to take you on a journey and introduce you to the talented artists, musicians, and creatives who share their incredible stories. A&E Showcase. Watch it on the ZNS network this fall.
I wish our audience could be here during the breaks. It's quite illuminating. So again, we've gone through about the rights once you are, in fact, you've been arrested and you're detained. Right. Now I want us to move along from there because again, Mr. Thompson, your experiences somehow curiously seem to be very different from Mr. Monroe's and I must say mine as well. But we're now moving now towards arraignment and you're now at court. You've been detained and extensions have been gotten, and so you're now at arraignment. I want to talk about, well, bail and two, let's even go back a bit further. Police bail. Is that utilized sufficiently, you think, Mr. Thompson?
My learned friend may be able to speak more on it because where I sit, the persons who will be vying for the bail will be the accused and their attorney.
I'm talking about police bail. The police granting bail to persons, letting them go, and then saying, we want to, of course, it's just for you to secure that you attend court. You've been charged and you're given police bail. Because I'm finding more often that persons are being held straight up to being taken to court, even for very non-violent offenses. They're just being held. And the police would say, well, no, we have to keep them until it's time for court. Why?
I agree with you if the matter is minor. If you have a minor offense, the police has the jurisdiction to grant bail to that individual.
But have you found in your position, because again, you are the director of legal affairs of the Royal Bahamas Police Force, are you finding, I don't know if you have statistics, are you seeing that police bail is being given less and less over the years?
I do not have no stats on that. And that was one of the reasons why I turned to Mr. Monroe, because I was of the view he may have more intimate knowledge as to whether his clients were granted police bail or not. From my point of view, it's only if someone complains and then it will come to my attention. But unless I get a complaint, I won't be aware of it.
So, Mr. Monroe, what say you about police bail being given?
Very rare. And as you rightly indicated, even for matters that are non-violent. And what I find interesting, we talked about people being invited to the station. Some persons who are invited to the station, when they reach, they are arrested, they are charged, and they're held and carried to court, as opposed if they are willing participants to come to you because you request them, why can't they be given bail to show up to court?
Yes. That's something that my husband always speaks to me about, Calvin Seymour as well, a pet peeve of his. Mr. Thompson, what do you say about that? Persons are invited to the station, they show up. In fact, sometimes they're even told, we're going to charge you, but yet they're handcuffed. And, I can't say paraded, but they're handcuffed. And then, of course, conveniently at about 12, 1, 2 o'clock, when the press are set up on the veranda, they then walk past and brought into court.
Well, that is in the past.
That's the past. That doesn't happen no more.
Well, it used to happen, but still, with your point about being arrested, you're invited to the station, you're arrested. Why do you need to be arrested?
Let's talk about bail, about being arrested. It depends on what they are arrested for. The police cannot give bail in certain circumstances.
Even if you're invited to the station
for
and
instance,
you show up?
Let's say a suspect is wanted for murder.
Yes.
And the police have a verbal communication with the suspect by way of telephone. That person is invited, say, we need to see you at the station.
And they show up.
They show up. You arrest them for murder.
Yes.
You charge them for murder. The magistrate, according to Section 4 of the Bail Act, and you know what Section 4 of the Bail Act say in regards to the magistrate granting bail, which means that for murder, the police doesn't have the jurisdiction to grant bail for murder. The police doesn't grant bail for murder.
No,
but the police...
Go ahead.
Whatever jurisdiction the magistrate has as relates to bail, the police has. And even in that case, the police still don't give bail.
Well, I'm just telling you that there's a difference between minor offenses.
We accept the indictables.
And indictable offenses.
We accept that.
The police department will not give bail for indictable offenses.
But are you still saying, though, that you don't accept, or as you've been saying, it's not been your experience that the police are not granting police bail in minor situations?
I will say this. I am aware of a few complaints that came to me.
Oh, so you are aware of
a few complaints that came to me pertaining to persons who were in custody for minor offenses. Once they came to my attention, I would always contact the officer in charge of the division and advise the officer in charge to grant these individuals bail. That's why I made the point of Mr. Monroe, because I don't know his experience. But if someone complains, the complaint comes to the Complaints and Corruption Unit, or the complaint comes to the legal office that someone is in custody for a minor offense,
and then you will act. You will act.
So that's why every experience that I encountered where someone is in custody for a minor offense, I have always acted and they have been released.
Okay. Yeah. So now we're at court. Yes, we're at arraignment. And the issue of bail. What presently, Mr. Monroe, able to speak, because many people want to know, there have been some slight movement and changes, because it was very restrictive a while back about who can be granted or be given magistrate bail.
Well, no indictable offense a magistrate has jurisdiction.
Such as murder, armed robbery, those offenses are out.
Armed robbery, attempted murder, manslaughter, rape, those things are out.
Yes.
Persons charged with dangerous drugs, possession of dangerous drugs with intent to supply, or just simple possession.
How about guns?
Guns as well. They can be granted bail.
And see, that's important for persons, because I think there's been a change.
It is a change.
Yes, because before we'd had to go to the Supreme Court for bail.
Yes.
But now you can get bail at the magistrate's level, which you agree, I think, has freed up the system, because it was really becoming somewhat, I think, cumbersome. As well as I believe many persons, unfortunately, were being forced, particularly in issues such as threats of harm or threats of death. In those instances where the magistrates were not allowed to give bail, I found that many people were perhaps pleading guilty just so that they wouldn't lose their jobs or have to go to jail and spend a week to 2 weeks awaiting on remand, awaiting bail. I don't know if that's been your experience as well.
Yes, it has.
And so I think that was really a dark period.
Yeah. Well, from sense, I could talk about the legal office. The legal office, we look out for the rights of every individual who's in custody.
Yes.
We are trying to be the gatekeepers of the Constitution. And that's why you find me saying this has not been my experience earlier. And I'm continuing to say that because anytime it came to our attention that someone's rights may be violated, we intervene. So all those cases, these persons, if their rights are being threatened, we intervene and it does, whatever's being done has been remedied. So that's why our experience have been so limited, unless someone
unless you have a complaint.
Yeah, unless we get a complaint.
Okay.
Yeah.
Gentlemen, so we're at this point. The person can have bail. They're at arraignment. Before we move into possible reforms, I just want to touch on whether it's been your experience now that they've been arraigned about preliminary inquiries. I found that we're somewhat shied away from those. And I don't know, what is your thought or feeling? Should we now revert back a little bit to having preliminary inquiries rather than just having a lot of things going by way of VBI, voluntary bill of indictment, moving matters to the Supreme Court? What's your thoughts on that, Mr. Monroe?
In some instances, I would say that preliminary inquiry you would find to be useful. In some instances, when you go by way of VBI, you have matters that once it gets to the Supreme Court, persons are waiting 3-4 years for the matter to be heard. Some of the witnesses during that period dies. The person is at a disadvantage who was charged before the court, didn't have an opportunity to test the evidence because, prosecution, they tend to rely on a certain section in the law to have these witness statements tendered, untested, and it creates issues and a disadvantage for a lot of persons that are before the court.
Yes. So you think PIs, more preliminary inquiries, because obviously you would then have a transcript.
Yes.
If the magistrate does deem that it's fit to move on, you, at least if something happens to that witness, you have
can accept
something
the
there
deposition.
the depositions. What's your view on that, Mr. Thompson?
This is my personal view. I agree with Mr. Monroe to a certain extent.
Yes.
Not fully.
We're getting close. Yeah.
PIs has its place.
Yes.
And I believe, because when we look at the calendar in the Supreme Court, it's impossible to try every case in the Supreme Court.
Yes.
I believe that if we utilize the plea bargaining legislation from the PI level, if counsel is willing to plea bargain certain matters from PI level, from magistrate level, those matters can be fast-tracked to the Supreme Court so we can have a plea in regards to those matters. Other matters that are not serious, such as murder and rape, those ones, they can go by PI, in my view.
Okay.
Yes, I think the more serious matters should be VBI, but this is my personal view.
Okay.
Yes.
Listen, do you agree with that, Mr. Monroe?
No, because you talk about plea bargaining, which means it don't give the person an opportunity to have their day in court. He specifically just talked about plea bargaining.
So you're thinking, let's have a preliminary inquiry, and then depending on how the evidence pans out, then we can talk about entering into plea bargaining.
Yes, you must test the evidence.
I think my learned friend missed what I'm saying. The plea bargaining is for his client's benefit, because his client may want to plea bargain out.
But I think he is saying, let's test the evidence first. Let's say maybe at a PI level, preliminary inquiry, let's see how things are going in order for that person. Because again, we can't, I don't think that we ought to belittle how stringent some of our sentences can be, as well as the condition of our prison. I mean, to spend a year having to defecate in a bucket and sleep on the ground. I mean, let's face it, the Bahamas Department of Corrections, even in the words of their own officials, the level is not where it ought to be. And so I think we have to be very careful when we're talking about any person to say, okay, take 12 years, 5 years, 6 years off of your life in prison.
I think the defense bar need to have a second look at plea bargaining. If you have eyewitnesses, video footage, DNA evidence, fingerprint evidence, all the stack up against you, why you want to go through a whole PI when the likelihood of your client being convicted with this mountain of evidence is so high?
I think I can hear what Mr. Monroe is going to say, but say it before we wrap up.
Well, the things he talked about, they would consider that to be cogent evidence that has not been tested.
Under cross-examination.
Yes.
And sometimes you tend to see things really unravel.
Yes.
Curiously, all of that evidence.
All I am saying is from experience.
Yes.
And you and I had many experience in the courtroom. And there have been cases where I have offered certain things to the defense counsel. Actually, one of them was one of the cases that you were a part of. You were not the counsel. You were just a part. You were representing one of their co-accused. And they refused. And we went through the case. We went through a full trial. And they were convicted, and they got a particular sentence. They would have gotten 2/3 of that sentence off had they accepted the plea.
Yeah.
It is for the benefit of the accused person to consider a plea. And I think the entire defense bar needs to consider plea bargaining, because what the defense bar is doing, when you don't consider it, you are giving your client a disservice. You're doing your client a disservice by that considering. I ain't saying you have to do it. Considering it.
I certainly cannot agree with you there, because particularly when
instructions.
I can't.
Once you put it on the table, you take instructions from your clients.
Now you're agreeing with me.
No, I'm saying.
My point. You agreeing with me now. My point is that you bring it to the table, you inform your client, and you allow them the benefit of doing it, and give them the opportunity.
Let me put it in your words. It has not been my experience that defense counsels do not put offers to their clients. But nonetheless, gentlemen, I think certainly we're going to need a part 2 to this. But just in going through from the point of arrest, from whether it's an invitation and knowing that if you're a suspect and what you have to say to the police, it's important. And I think we've canvassed here that civilians, persons, they have rights. Yes, sometimes there's a feeling that if the police stop me, I have to do what they say. I have to go along with it. So it's very important, I think, and we brought to bear that no, you do not have to cooperate. You do have the right to remain silent. And as you said, yes, there are times if you so choose to do so, but it's still, you're making an informed decision, knowing what your rights are. It's not that you're acting out of ignorance, which can be very detrimental. Yes. But listen, this has been great. We're gonna have to do this again to take this further. Particularly, I'm hoping that we can get my learned friend here, him to have more experiences akin to what we experience out there. But it certainly has been a pleasure to have both of you to discuss.
Yes.
And thank you for watching and joining us and learning from the point of arrest to arraignment. What are your rights? Until next time, on The Legal Brief, I'm your host, Ramona Farquharson. Thank you for watching The Legal Brief. Be sure to like, comment, or subscribe for more.